video then. I guess that's fine.
All right, good morning, everyone. This is Andrew Drzwicki. I'm calling the Board of Review to order at 9:02 a.m., I believe.
Would you like me to call the roll?
Yes, please call the roll, Jennifer.
I will now call the roll. James Jaworowicz.
Here.
Michael Braswell.
Present.
Donald Reed.
Present.
Jerry Willahowski.
Present.
Andrew Drzwicki.
Present. All right, the first order of business, Mr. Trout, I believe that's you, for Fred and Penny 4111 LLC. If you would, please come up to the podium and, as usual, state your name, who you're representing again, so that we have all that on the record.
Would you like me to read the case into the record?
Yes, that as well, while Steve's preparing there.
Okay, my name is Steve Trout. My address is P.O. Box 395, Pewaukee, Wisconsin, 53072. And I'm representing the property owner. I'm going to have two expert witnesses or two other people speak to you, since we're at the beginning part of the meeting. Do you want them to be introduced? And
So we'll
Yeah,
call the
as-
case
as
first,
we-
and then we'll deal with the preliminaries. So just
okay.
hold on.
Okay, so I will read the case into the record. This is the case of Fred and Penny 4111 LLC. I'm going to repeat that. My mic was not on. This is the case of Fred and Penny 4111 LLC. The property owner objector, or the address for the property in question, is 4111 South 108th Street in Greenfield, Wisconsin 53228. The tax key number for the property is 566-9958-002. This property has been classified as commercial. The 2021 value in assessment roll for land is $1,467,500. Improvements, $3,324,500 for a total assessment $4,700 and is that 12 or 42? Total assessment of $4,792,000. Would all persons, including the assessor, intending to provide testimony for this hearing, please raise your right hand to be sworn?
Do you want these guys too?
Yes,
Anybody.
They'll have to, yes.
anyone who will be providing testimony. Do you solemnly swear that the testimony which you shall give in the matter now on hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
And now, would each person who has just been sworn please state your name and address for the record? And I would ask those in the audience come to the mic and state your name and address for the record, please.
Sure. Michael Grota, Assessor, City of Greenfield, Main Street, Menominee Falls.
Steve Trout, Traudt. Address is P.O. Box 395, Pewaukee, Wisconsin.
Jerry Erdman, Property Advisory Group, Ltd. My office address is 970 South Silver Lake Street in Oconomowoc. Erdman, Erdmann.
John Ford with Catalyst Partners. Office address is 13150 Watertown Plank Road in Elm Grove, Wisconsin. Ford, F-O-R-D.
And would the city assessor please state the estimated level of assessment for the current year?
For the commercial property, I believe we're at 92%.
Thank you.
Steve, I know you're mostly familiar with how this goes this morning, so I'd like to open the ability for you to present evidence according to what you're trying to disprove at the moment, which is that the assessment currently in front of the board is incorrect.
Yes, sounds good. Okay, so just a little bit of background. My name is Steve Trout. I've been in commercial real estate for 25 years. I do a lot of sales and leasing. Every day I'm talking to buyers and sellers about the values of properties. So I really know and understand valuation in the Milwaukee area and of commercial real estate. I've got a couple of handouts that I'd like to give, and then I've got a couple people that are going to speak on my behalf or speak about the issues and some of the experience that they have with this property and how they understand the value to be. The first handout that I have.
Yes, for the record, thank you.
Thank you.
Thank you.
So Madam Clerk, we'll mark this one as Exhibit A. It looks to be just the objection form, if I'm not mistaken.
Yep. That is correct.
Okay, I'm just wanted to make a point with regard to the objection form that we use for the Board of Review, and I've underlined a sentence in paragraph C where the Board of Review is asking if during the last 5 years, this form is asking if during the last 5 years this property was offered for was listed or offered for sale. And the response here is yes. And the reason being, I'm in commercial real estate and I have offered this property for sale to potential buyers. And I've got a few things that I want to hand out to substantiate that. Thank you.
Thank you.
Yes. So then we'll mark the set that is the email on the top page. We'll mark that as Exhibit B.
Okay.
And then the commercial offer to purchase will be Exhibit C.
Okay, so just so everybody knows on the, which ones did you mark as the exhibits?
B is the email.
Yep.
And C is the offer to purchase.
Okay, referring to Exhibit B, this is an email between myself and the clerk and Mike Groda. I just wanted to demonstrate to the board that we're really close on this value. I've been working on this for more than 2 years, and I did a full valuation last year, and I had the assessor visit the property. It wasn't Mike Groda, it was his partner, Dan Storm, and we tried to work on the value, but they didn't budge and kind of said, you know, you really need, it would be helpful if you had an appraisal. So now I don't always need an appraisal to do my work because I put valuations on properties all the time. But I did get an appraisal, and the client paid for the appraisal. So we do have a professional third-party appraisal on this property. And we'll be talking about that shortly. But I also wanted to show the emails of people that I offered the property for sale to. So if you turn Exhibit B to the second page, I offered the property to sale, or for sale to the Ergens Company, to the Ryan Companies, and to many other companies to see if they were interested in purchasing the property or redeveloping it. And the offering price that was in the emails was $3.45 million. So anyway, I think that these emails demonstrate that, and the email to the assessor shows that he was well aware that we had an appraisal and that we've offered it for sale, and the Board of Review application form considers that to be kind of an important piece of information which we've provided. So for my first witness, I just want to ask John Ford to come up and maybe answer any questions you guys might have. But the point is that he is the president of Catalyst Development Partners. Now, Catalyst also has a construction company, and they're very active in building buildings and developing real estate in the area. The construction company actually is doing a project in Greenfield that's off of the Highway 45, so it's just north of Beloit Road, and it's a large medical office building. And so these guys know a lot of tenants, they know a lot of users of real estate, and John was good enough to come to the VC building and tour it and consider it for redevelopment and purchase. So, John?
As Steve said, John Ford, president of Catalyst Partners. I can confirm we did tour the VC building, took a strong look at it. We are a developer here in Wisconsin and the greater Midwest. As Steve indicated, I was part of the development team that brought WB to Greenfield here for the rehab hospital over on Oklahoma and 45. That's currently under construction. We pretty much, as a development use, we focus primarily on hospitality, multifamily, student housing, senior housing, as well as medical and so forth. We toured the asset. It was offered to us at, as Steve said, at the $3.45 million purchase price. Ultimately, we took a pass. We typically, obviously with real estate, buying a building on spec is obviously challenging at times. So unless we have an actual user, it makes it obviously more challenging. So for the time being, we've taken a pass, obviously, but we're certainly active. We like the location and so forth. But I'm happy to answer any questions that the board would have.
Do any of you have any questions at this time? Otherwise, I'll let them continue.
Not at this time.
Okay.
Thank you.
All right, so in addition to that, I'd like to talk about Exhibit C. Now, this was an offer that came in last year, and it didn't get accepted. It didn't go anywhere. You can see because of the date, it was March 9th of 2020. There were some, that was when COVID was kind of ramping up and a little uncertain in the world. The two things I just wanted to bring to your attention is that the offer price was $3,850,000, and then there was a closing credit of $350,000 that was part of this deal. So the true economic value of that offer was $3,500,000. Anyway, it's another just indication of value. I'd also like to bring up Jerry Erdman as a witness, because Jerry has actually met with the owner and the owner of the property, the taxpayer, and has had conversations about the value of the property. And Jerry is a broker, so he really knows development, he knows brokerage, he knows leasing, and he knows and understands values. So Jerry.
All right, thank you, Steve. My background, became a licensed real estate broker in Wisconsin in 1986. So I've done this for in August it'll be 35 years. I've developed about $200 million in commercial real estate myself that I've been the active developer in, anywhere from medical, retail, office, and industrial. I've brokered almost $2 billion in commercial real estate in my career. I've been actively involved in brokerage and leasing for a number of years. So Steve introduced me to the property owner last April in the middle of COVID. She had expressed that, one, they would like to potentially exit the property, but two, they were concerned about it becoming public, and then it affects their business. So it's a very delicate balance when you have that situation to try to market a property and do it quietly off market. So, which I do a lot of. I do a lot of off market type transactions. This year I've sold over 30 million. I've already closed over 30 million this year. And half of those transactions were considered off market. So we did a valuation and determined that we should market the property at $3,450,000. And she kind of gave me an open engagement where it wasn't exclusive, but she allowed me to present it to individuals that I thought may be interested in the property. So we did make some phone calls. We put a generic flyer together, not a full marketing flyer that I would normally do on a full listing, and approached a variety of types of users, actual users versus developers, because we thought a user would be the best use for the building and pay the highest price. We didn't get much traction April, May, June because of the COVID, but as we got into the summer and fall and winter, there was definitely people wanting to engage or at least listen. We have not received any offers of the people that I've presented it to. I'm not sure, she may have given other brokers open listings too. I believe she has talked to other brokers, but I don't 100% know who they are. So I presented it to a number of buyers, and the building itself is really just a shell of almost like an industrial type building that's got a specific build out on the interior of the building for her school that really would not be usable for anybody else other than her business. And if you look at a medical user, they would gut the whole thing. We've tried to present it to people like Aurora, people like Ascension, people like Freighter for surgery center, medical office. That hasn't played out with any of those users. Smaller medical groups we've talked to, car dealers, office users. The office market pretty much right now is in the toilet in probably the whole country, but even here, it's just a tough market in commercial real estate right now.
So Jerry, quick question. What do you think of the assessed value being at?
I don't even remember what it is.
It's at 4 point.
Well, I'm looking at fair market value, and I believe that, if we did a full listing, we marketed this thing properly, we had it out there with signage, put it on all the LoopNets, CoStars, Craigsies, email blast, the way we normally do brokerage, we would list it at $3,450,000 and expect to sell this somewhere between $3 million and the asking price, depending on how competitive. The thing is finding a user that needs that building in that location, and that's a difficult task. So from a sale perspective, what I believe the market value would be in this year would probably be somewhere in that 3.2 to 3.3 range. I believe if we had a full listing. Without a full listing, it's hard for me to go and market a property. I can only call people and try to present an idea, and which I have done with about 20 different buyers, and we have not received any offers. I don't know if there's any other questions regarding that.
So you were not involved then in the offer to purchase with ACG Acquisitions at all?
No, I did not meet Penny until after that date. So I don't know, like I said, I know she's talked to other brokers and given them kind of verbal open listings. I'm not sure what her engagement was with that broker.
And in your experience in this type of market, what would you anticipate a fairly typical marketing period to be?
Well, with that building being that it would be an owner user because she would be vacating the building, I would say that it could take 6 months to a year. You know, so other things where I would do a lot of investment real estate, that stuff is selling very quickly. I mean, we sell that in 30 to 60 days. But owner user on this type of property, 6 months to a year, I would think.
I have a question or two. When did you start listing the property, marketing it roughly?
Well, I believe Steve introduced me in April of last year because he said, Jerry, hey, I have an opportunity of, you know, property where I believe the property owner would like to exit. We met with her, and then so probably we didn't do anything in April, I don't believe. April was kind of chaotic trying to salvage everything else I had going on with deals that were falling apart. But by mid-May, we were out talking to buyers, and really probably June through the end of the year, we presented it to about 20 buyers.
One more question. Your 3.45, you mentioned that a potential buyer would probably have to gut the building, that its present use
Yes.
probably wouldn't apply to most buyers. Is your 3.45 value estimate of the building being built out, or is it of the building being gutted? Because there's a cost, there's an expense, and a value, you know, to those improvements that have been made to the property.
Well, there's a value maybe for that user,
Right.
but for the users that I'm going to bring, they don't see any value in that build out.
So your 3.45 is as a shell then?
As is, the buyer would buy it and have to gut it themselves, but it, you know, it's as is. The buyers that I presented, the buyers that I'm showing it to would not put value on that interior. They look at it as an expense of something they have to remove. There might be a few offices in one corner that they might be able to salvage or something, but
Thank you.
if that answers the question.
So, yeah, I got a quick question. So what would be the percentage then they would need to gut, you think? So what would be the percentage then, you think? I just kind of guesstimated the
Well-
percentage, because you said they maybe keep.
You know, in my years of doing this, and I own a lot of properties where one tenant exits and a new tenant comes in, it could be anywhere from 80 to 100% because it's, you know, what my business might be versus the next person's business is totally different. I just don't see a user in that same business taking that facility the way it stands. So it'd probably be at least 80% of it would probably be
Got it.
gutted and renovated.
Okay. Thanks.
Thanks so much, Jerry. Yeah, so Jerry emphasizes the point that I think the building should be looked at from an assessment standpoint and from a marketability standpoint and from a value standpoint, basically as a shell, because it's such a special purpose building. It's bigger than anyone in that business would ever build it, and it's just all purposely built for that one specific user. And so it shouldn't be assessed at cost. It should be assessed at 100% of fair market value, which we think is somewhere between $3 million and $3.5 million. So anyway, I also have this third-party appraisal that we've done, and I have I think one full copy And
Steve, to interrupt briefly, I believe we do all have a copy of that.
you do all
the
have it? Okay,
50
great. So
document or
I
so.
just wanted to mention that I have a few copies if somebody needed one.
I guess just to make sure we're talking about the same one, you're talking about the one that indicates that it's a date as of January 1st, 2020, completed by VSI, that's Value Services Incorporated, with a cover letter on it of June 7th of 2021.
And what's the concluded value?
3,420,000.
Yes, that is the one. So, just here to answer any questions about that. It is, it's a complete appraisal. The reason the valuation date is January 1 of 2020 is because we had appealed last year's value, and so we needed a retrospective appraisal. So it was recently done, and it anticipated the value of what the property was on January 1st of last year. But I've talked to the appraiser, and so I've dropped that legal claim. I no longer have any rights or arguments about last year's value. We just dropped it in order to get the value right this year. And sometimes we do that in this business of negotiating with assessors and just trying to get values right. So the appraiser has assured me that all of this information is accurate. The value still stands today. The appraisal was recently done. And we actually did this appraisal in a format, in a way that the assessor requested it to be done. So in my valuation summary that I provided last year, and we also reviewed it again this year, we used a lot of comps that were, some were former Brennan's, as a shell, very similar to the subject property. Gulf Galaxy's recent location, recent sales in similar locations. And so I did my valuation summary and came up with a value of $3 million. He did his appraisal report and focused more on school properties that have sold. So anyway, that is the purpose of the appraisal, and I also think that that supports the value. I think that's really about all I have. I think I'd just like to pass around this valuation summary that I had provided last year, and this was the basis of my valuation. I only have 2 complete copies, so I'll just go from left to right.
Thank you.
And if you want to just take a look at this, I only have 2 complete copies, but the assessor's seen that, and that's just my valuation.
That's the original copy. Gentlemen, is there anything else you'd like to ask before we close what would be the evidentiary portion of the hearing here?
I have a question or two. Now, the appraiser isn't here to answer questions about the appraisal that he prepared, is that correct?
He is not here.
Okay. I don't know if you can answer this question or not. The sales that he used, were those sold for redevelopment? Were they sold to be redeveloped? Were they sold?
Well, that'd be E now.
Are they is it an apples to apples comparison? Is it, a building that's going to be gutted and redeveloped? Is it a building that's going to be torn down? Do you know anything about that?
Yeah, they're completely an apples to apples comparison. That was the purpose of the appraisal, because the assessor said that my appraisal or my valuation work the uses were changing. But I really don't see that as an issue in determining what the fair market value is. That's just the reality in commercial real estate when you build a special purpose building. I can see it coming in some other circumstances, but that's not the case here. Bob Watson, the appraiser, is very experienced. He has 30 years of experience. He tried to give us he found comps that were schools. Some of them, I mean, what does a school become when it sells? I mean, it could be an office building, it could be retail, it's some other use, it's space that people need to use. Not necessarily should it be another school. That's more of a business enterprise value. If you're going to sell a building that's a school to only school users, that's a really small market, and I don't think that's what fair market value is. But I know that one of the comps in here was a Paul Mitchell beauty school. So Paul Mitchell makes hair products and is in that kind of industry, in that business. So very similar. These are all really, really good comps, and he took all those things into consideration. I think Bob Watson, like I said, he's been in the industry for a long time. He worked for a large commercial appraiser. He has a boutique firm now. He has his MBA from University of Wisconsin-Madison. He's about as good as it gets.
Thank you.
I have a number of questions, but I want to let you guys go first.
Honestly, we probably have the same questions, so if you'd like to go ahead and ask.
All right, so before I do that, just for the purposes of the record, we'll mark the appraisal as Exhibit D, and then the valuation summary handout that he had from last year as Exhibit E. My first question, Steve, is you don't think that there's been any appreciation in the market since January 1 of 2020 to January 1 of 2021?
On this property? For this property?
Well,
or are you talking about your house? Your house?
Let's just start in general on commercial properties.
I don't see how it's relevant.
Why wouldn't it be relevant?
Because we're talking about the value of a specific property.
Well, give me an answer anyway. We can let
on this property. No, I do not think there's been appreciation.
Okay. Do you think
it's in the same situation that it was?
Think in the commercial marketplace that there's been appreciation over the last year?
It depends on what specific property you're talking about and the asset class, that sort of thing.
Okay. I'm going to actually ask the two other folks, Mr. Erdman and Mr. Ford, to just kind of pay attention as I'm going through here. I may have some follow-up questions for both of you as well. So the appraiser is not here today, correct?
No, he's not.
So he's not able to testify as to any of his opinions in his report?
No, he's not here. I could possibly get him on the phone. If you guys would like to take like a 5-minute recess or something like that, I could see if I could get him on the phone. I think that might be helpful.
Well, we have a whole process that, for testimony by phone or otherwise that would need to be followed. And, obviously I can't speak for the board. They're the decision makers. But let's say, I guess,
We're really not set up to do that this morning, in all good honesty, if we're really going to do that and follow the rules to the letter. We're not.
Well, the appraisal stamped, signed, certified, it's done by a professional.
No, and I don't disagree with any of that, but let's just talk about the appraisal a little bit. He identifies three
Well,
comparable.
if he's not here, and
You are submitting it as evidence of
Yes.
value
Yes.
that you are relying on.
yes,
That gives us fair
relying
game to
on the
ask
number.
you questions about the appraisal that you are submitting.
and now can I just ask a question about your role, Brian?
My role is as the city attorney. I
Okay.
represent the board to
Yeah.
make sure that they are proceeding in the right manner. My role is to make sure that the record is complete,
That's fair enough. Okay.
and so that is my role.
I just remember last year that the tone that I thought we really had a very productive meeting last year, and that the tone of the meeting changed after you took charge. And I just want to, I've put so much work into this. I represent the taxpayer that's being overassessed, and I've really done my best to put forth a case that this board can make a judgment about the value. I've done so much. And so anyway,
Okay. So in any event, he identifies three comparable sales.
okay,
One in Grand Chute, one in Middleton, and one in De Pere.
okay.
He doesn't appear to make any adjustment in his sales for location of any of those buildings. Do you have any idea why that is?
They're all, I would think that they're all comparable markets to the subject property, and the properties, the position in their market is very similar to the subject property. And so, they're in Wisconsin, and they're in similar markets.
So the property, for example, in De Pere, which is a handful of blocks away from the new stadium district in Green Bay, is the same type of commercial market as we would see on Highway 100 in this location.
I think he must have thought so.
Okay. Likewise, you have a subject building that is approximately 31,000 square feet.
Yep.
That same building sold for or has an area of about 13,700 square feet, according to the appraisal.
Right.
He's made a negative adjustment for that size difference of 2.5%. Do you have any idea of why he made it as only 2.5% versus some other number?
No, I do not. I trust his professional opinion for, making those kind of adjustments.
Okay. I note that the subject building appears to be effectively a single-story building. Is that correct?
Yes.
I see that the first two, the sale number 1 in Grand Chute, sale number 2 in Middleton, both appear to be two-story structures. Does that, in your opinion, make any difference as the value of the properties?
Let's see. I think it can be very similar.
Okay. So we have a sale date in the first sale of December of 2018. I do not see, he does make an adjustment for that sale of about 2.5% from effectively that 2018 date to the January of 2020 date. Any idea how he arrived at the value of 2.5%?
I'm sure it's just from data that he reviews and what he understands about the market.
Okay. And do you have any idea as to whether or not he would have an opinion as to whether an additional adjustment for that additional year would be appropriate?
No, I don't think so. I think that he's a very qualified appraiser and that he does good work.
Okay. Similarly, on the two second and third sale, May of 19 and December of 19, he makes no adjustments to those sales at all. Any idea of whether or not he would have an opinion as to whether an adjustment for time would be necessary based on either of those sales?
I think I think that time is very similar to, I don't see why you would make a time adjustment.
So I'm going to go to Mr. Erdman.
Steve, thank you.
Would you agree with that discussion about time adjustments between a sale in 2018 and 2019 as it relates to a 2021 valuation date?
Well, I haven't read the appraisal or seen it, but two, I mean, yeah, your data wants to be current as of the year that you're talking about and the type of property you're talking about. I don't know what sales he's talking about or what the appraiser, so I'm sorry I haven't seen that document.
Okay. And do you have any opinion or thoughts as to whether or not a two-story building versus a one-story building is going to give you similar values?
Without knowing the two different buildings, I don't want to comment on that, I'm sorry.
Okay, fair enough. That was all the questions I had for you.
Thank you.
Thank you.
And Steve, we're going to go back to you just real quick. So you give us Exhibit C, which is the offer to purchase document. Any idea why that transaction didn't close?
I really don't. It's just demonstrating a value. It's just a data point.
Was the offer accepted?
No, not that I'm aware of.
Why?
I don't think so.
Why not?
I don't know anything about it. I don't know. It's just a data point. It's just showing a value.
Were you involved in the transaction?
No, I wasn't.
I have nothing further.
Based upon proceedings, Mike, can I ask you a few questions just to explain what you've done for the purposes of the board understands? Is that all right with you?
Would you prefer that before or after my testimony?
Let's do the testimony first and then that, please, if you would.
Okay. So no other questions for Mr. Trout?
No, I think we're good.
And then we'll mark this as Exhibit F, the whole packet.
Okay. Thank you. Thank you, sir.
So then I guess just not realizing Mike changed it up a little bit on me from what I've normally seen. So in light of the fact that we kind of have three separate pieces of that document, we'll still just call it Exhibit F, but just for the purposes of as we're going through, the first piece of that is starts with the property record card. The second piece of that is a part of the property assessment manual, starting at page 10-3. And then the next piece is all of the kind of loosely bound pages, starting with an email from Dan Storm about some comparable sales.
Great.
Whenever you're ready, sir.
So the first paper that I have here is the summation of the property record card. Again, the building was built in 2003. It's just over 30,000 square feet. As I did not find what I thought to be comparable sales in the local market, I went to the next two approaches, based on Markarian hierarchy. Sale of subject or reasonably comparable sales is the first tier. The second tier would be the income approach, and then the third tier would be the cost approach. I've done both the cost and an income. The cost approach would lead us to a valuation of $4,844,000. That is greater than the 2020 assessment. However, the cost approach is the least reliable of the three approaches. The third paper and the fourth paper is the income approach. We did an income approach based on a triple net lease using $15 a square foot. We arrive at a value of $4,287,200. Based on that 2021 income approach, we made an adjustment to the 2021 assessment for this subject property from just under $4.8 million. The next set of papers that I've got relate to the property assessment manual and guidance for usable sales. And I think that to use a sale, you need criteria that reasonably matches the subject property. Yeah, same highest and best use, similar location, needs to be an arm's length sale, one that I guess not of convenience, not of foreclosure, one that was actively on the open market. And then the next set of papers refers to the property assessment manual and the assessor's consideration of comparable sales or sales in general, and how that test is performed in Wisconsin in reporting to the Department of Revenue and in using arm's length sales. And then I believe the next set of papers starts with an email from Dan Storm. And his comments in relation to the appraisal that was presented. Certainly, Mr. Watson is well educated. I've seen a number of his appraisals in real estate assessment cases. I guess I'll start off with each of these properties was dark at the time of sale. So how I feel that the sale relates to the subject property is that each of these three sales are very different. Is that the subject property is an operating entity that's economically viable and is still performing. Each of the three sales was dark and was for change of use. The subject property isn't in that position at this point in time. And so they are not reasonably similar in their current use at time of sale. Further, comparable number one, immediately after the sale and its change of use, there was $2.4 million invested to change the use of that property. Comparable number two, again, shortly after closing, he had a building and addition and remodeling permit for $7.5 million. Comparable number three was a foreclosure, a sheriff's sale. Each of these three sales, and surely comparable number three, is not an arm's length sale under Wisconsin law and the property assessment manual. Arm's length sale needs willing buyer, willing seller, under no duress, under normal financing terms, and marketed for a normal or reasonable period of time on the open market for that type of property. I don't believe that any of these three sales meet the test of arm's length sale for the purposes of comparison for assessment. I think on behalf of the assessor's office, we've certainly spent reasonable period of time in viewing the subject property. We've considered all three approaches to value. I think we've tried to look at what the current market is in the city of Greenfield. For this type of property, we've complied with Wisconsin state statutes, circuit court, Supreme Court cases, as well as the property assessment manual, which is the Bible for assessors. I've got nothing further at this point in time other than I think we've followed best practices, and the current assessment at just over $4.2 million is reasonable and correct.
Mike, to confirm for the rest of the board, for these particular properties that they've represented as comparables, just to state for the record again, why would these not be considered fair to be used?
I believe that all three properties were dark. Mm-hmm. So there's been lots of litigation, primarily with big box type properties, that has come down to, for example, a sale of a Walmart that is operating has a different value than one that is dark or has been shuttered. And the Wisconsin Supreme Court case, actually it's a Court of Appeals, not a Supreme Court case yet, has said that in order to be a similar sale, the property needs to be similar in use, needs to be open and operating, and that you can't compare a viable entity with one that has been dark or shuttered.
Thank you. Gentlemen, are there any other questions you have for Mr. Grota? All right.
I do have.
If you'd like to, be my guest.
A couple. So Mike, just starting your kind of third set of your exhibits here, the email from Dan Storm indicates that Comp 3 was a sheriff's deed in July of 19 and that it resold in 2019, and that may be part of the reason why it's not an arm's length sale, aside from the other issue that you just discussed, that a vacant building and those types of concerns. If I'm looking at the appraisal, it does look like they utilized that December 19th sale. Does that impact that analysis at all in any way?
Well, a foreclosure follows the property. The sheriff, or when it goes to foreclosure, it's under duress. and that duress stays with the property until it's a meaningful buyer. So if that meaningful buyer purchases it and then resells it, then it could well be arm's length.
Okay.
But-
And you don't think that happened here?
It's not, yeah, I don't believe so.
Okay. And you do work throughout the state, as I recall, correct?
Well, currently, we service 81 communities, primarily in southeast Wisconsin, but Marshfield is our furthest community, is the city of Marshfield, as well as city of Sheboygan, city of Fond du Lac.
Okay. Are you familiar with Grand Chute, Middleton, and De Pere at all?
Other than being in those communities, I'm not aware of their individual markets.
Okay. So do you have any opinion as to whether or not those locations are truly comparable such that no location adjustment in the appraisal would be appropriate?
I certainly believe there should be some adjustment for location. Not knowing the individual properties, I don't know what that adjustment should be.
Okay. And in terms of increases in value year over year from 2020 to 2021, on average, we saw an increase in commercial properties?
In some types of commercial property, yes.
Okay. Would this be one of those types of properties we would expect to see that?
Possibly.
And then do you have any opinion as to that issue of one-story versus two-story and how that might impact the analysis in the appraisal?
Typically, a one-story building has greater function. We certainly know it would cost more to construct. Typically has greater utility.
That's all I have.
Okay. If nothing else from you gentlemen, then I'd like to move to.
Hold on. Mr. Trout, did you have any questions for the assessor?
Yes.
Yeah, I do have a few questions.
Let's see here. So Mike, what if you have do you believe that the subject property is a special purpose property, that it was purposely built for a specific user?
Certainly, it is, its functionality revolves around the school, yes.
Okay, so that's yes. Because it was developed by them and it was developed for them, they designed it and they built it and they use it.
Sure.
So how is it possible, and if they have a very unique business model, like one we really don't see, that we really don't have another example of that business model, how is it possible to find comps and to do your appraisal work or your assessment work without having direct examples of special purpose buildings? I mean, this must happen all the time. I would think that alternate uses are just a reality for special purpose buildings.
Well, I'm not sure truly what your question is, or you're asking several questions, so what?
Okay, let me just restate that. So you agree that this is a special purpose building?
Yes,
It was
is
purposely
unique.
built for them. And so I think that to say it's unique, do you believe this building is unique?
Sure.
Okay, I agree. And so just by definition, if it were to come for sale and someone else were to use it, it would most likely change uses.
It's highly probable that there would be a change of use. if the business is not sold with the building.
Sure. Right. So yes, it would, and then that's the valuation technique that you, because if we're supposed to be assessing at 100% of fair market value, then we should be trying to determine what a building is worth to others. What is it worth to the market?
Well, I think the dark store theory in the current case law would say that you value it based on its current use, not on its most probable use if there's a change of use.
You said that that's
Different
being,
valuation principles.
I think you're misapplying, okay, so I don't have any questions, but I think, to the board, I think that he's misapplying this dark store theory that nobody understands. Let me see if I have another question for Mike. Do you have one, Jerry?
Well, you know, when we talk about the existing use, if you take like a Walgreens, there's a value to that Walgreens that's occupied based on the credit of Walgreens and the financial instrument that is in place, which is the lease. So when we sell net leased assets, and I'm selling a Walgreens, there's a lot of factors the investor will take into consideration, and those assets are typically selling based on the credit of the quality of the credit and the length of the lease and the terms and conditions written in that lease. So if you take this tenant in this location and you're going to value it based on the value of what the occupied space is with the current occupant, you have to look at the financial statements of that tenant. And what is the viability of that business? I don't think that's how you can value this property, because if we did that, then the value would come way down. Because, you know, so you're looking at a building, if you take a vacant Walgreens, then you're looking at the value based on the underlying real estate value. And that's what I look at with this building, the underlying real estate value. If she wants to sell this building, how is someone going to look at this building? It's basically a shell, a doctored up shell that's got that really is almost built like an industrial building with a really neat build out for a school and a hair salon and that type of thing. So the underlying value to me is a broker is what we have to look at, because no one's coming in to buy that as a school. There's no viability for her to sign a long-term lease and me to sell that as a investment asset. So I don't know if that makes sense, but I just had that comment.
Any other questions for Mr. Grota? All right, now I'll move to close and do open discussion, if I'm not mistaken. Steve, I'm going to go over a few things with the rest of the board here and generalize for my thoughts on the open outstanding issue, so if you'd please follow along, I'd appreciate it. So the main thing that I want to talk about with all of you is the fact that the main argument that they're trying to make, or at least from this assessment that they had done, and I'll quote from this sheet, is that it says, to establish the assessment for the subject property, the assessor relied on the cost approach and income capitalization approach to market value. The assessor erred in establishing the assessment for the subject property by failing to consider recent sales of similar properties. Now, Mr. Grota just got done telling us why these would not be considered fair comparables, if you will. So at the end of the day, Steve wants us to believe of the opinion of what's been presented, that Mr. Grota has made a mistake via the Markarian hierarchy, which is the three-tiered approach here, which Mike also just talked about. The problem with this is, even in the event that Steve could prove to us that the value of this building is $1, we don't have the authority to grant this change in value. And the main reason behind this, and if someone would like to correct me if I'm wrong, is that the state of Wisconsin does not want us to have the ability to give the owner of this property a discount, because they also lose revenue at the state level. It's not just the municipality, it's the entire enchilada, if you will. I cannot take these into account based upon that testimony, and I can't really use this assessment.
It's an appraisal, the appraisal?
Appraisal, yes. So Exhibit D specifically. The gentleman's not here, and I know we've had some questions asked about this to more or less understand where he's coming from, but go ahead.
Andrew, I really appreciate you guys taking the time to be here. I really do. You guys are great people and really thoughtful, and you're giving us a chance to be heard. Please, please, please do not take that away. And I just want to say that you guys are in charge. You guys can. I've been to Board of Reviews many, many times, and boards just like you. I've been to Greenfield. I think one of my first Board of Review meetings was probably 10 or 12 years ago in Greenfield with some really nice people, and maybe some of you were on the board, and I was successful. And it didn't go like this. You are empowered to make the decision. You guys can choose. I had a $3 million value on this property. I changed it. I came up to the 3.5, and then we've substantiated that in so many ways. And I think the assessor knows that I think he knows that I'm right. I think he's just choosing to use the cost approach. It's less work. It makes sense from his standpoint. But to get to the right number, I am just trying to help this taxpayer. And I'd ask each and every one of you, I don't know if you all live in Greenfield, but can you imagine if this was happening to you? If your house was overassessed so much that you were paying $35,000 to $40,000 a year more than you should be, and I've given you everything that you need. Just please have the courage to, just uphold my value, and we'll move on, and we'll go away. Nothing will change for any of you. It's okay. I've done it 20, 30 times. You can do it. Have the courage. Otherwise, the system is not set up for the taxpayer. The whole purpose of this is so if your value changes, you have an ability, or if your value is not right, you have the ability to provide evidence. And sometimes we just want to stir it all up and make it so confusing and then punt. But that just really is not good for the taxpayer. So imagine if this was happening to you. I'm asking you, please, someone make a motion to support the taxpayer's value of $3.5 million, and let's have a vote. And then I just need 2 others to join. It's so easy. But if this was happening, imagine, this is the right thing. You'd be doing the right thing. Thank you.
A couple of things, Steve, as I go through them. And you can sit down if you'd like. This building has never actually been sold for $3.5 million or $3 million or even anything that we had talked about in the last 12 months since the last time you were here. we're not in the position that I can just make a motion and do this. You're of the belief that we are, and the statutes were different, let's say 10 or 15 years ago, where we might have had more authority as the municipality to make this change. The particular argument that you're making here at the back of the appraisal is something that is typically only heard in an actual court, which means you're going to be in front of a judge.
Not true, Andrew. Andrew,
There's
you don't
a
have to
number
make
of
the motion.
cases-
Anybody can make the motion.
There are at least 3 cases that I've gone through at the state level that even made it to the Supreme Court arguing the same issue that you're presenting us right now. Even though this is a different subject property, it's the same argument.
This is not a Walmart. This is a local family
You know, I'm not
that
ta-
owns a
I'm not
small
talking-
business.
I-
Yeah, you're talking
I'll
about.
give an example of, we'll take Southgate Apartments. So this was a case that made it to the Supreme Court in 2018 here in the state of Wisconsin on an appeal from the original circuit court case where Southgate tried to make the same argument where the valuation of this property is X.
So it's an apartment building? How is an apartment building unique and a special purpose built building? It's not. It's completely different, Andrew.
I know, so what I'm trying to get, the point that I'm trying to get to is this particular argument, bringing the validity of whatever type of use of that building is, has to be done at that avenue, and that's why
It's
I asked-
impossible. It's impossible. That's not true. What you're saying is not true. I'm sorry that that's what you've been told by attorneys and read between the lines. But I know that if you guys have the courage, if you have the courage to make a motion and agree with me, you will be doing the right thing. And if you don't have the courage to do that, there will be injustice done today.
Well, I'm going to jump in at that point. The right thing for you guys to do is to follow what the law says. And while Mr. Trout is absolutely correct, you guys have, in fact, I've made the same argument he has, praying that, you know, a board that I was appearing in front of would make a change just to help me out. But at the end of the day, the right thing to do is you follow the law and you apply the law.
Brian, that is not true at all. You are working against
That is
me.
100% true.
They can make a decision. All they have to do is make a motion and go.
Yeah, you're absolutely right.
Yeah.
But if they make a decision
Say that
is
they're
not
breaking the
cons-
law and they're going to be committing a crime?
I'm
Is
not-
that what you're
I'm not-
insinuating?
I'm not suggesting that they're violating or committing any criminal violation
Well, then-
by doing that. What I'm saying is that what the statutes contemplate, what the
Contemplate?
what the case law contemplates.
I've done this 20 times,
is-
30 times.
I
It's
don't
fine.
care about. I don't care about 20 other times. I don't care about 10 years ago, last year, whatever. We're here to talk about today.
Yep.
And the fact of the matter is that this board swears an oath to uphold the law of the state of Wisconsin.
Mm-hmm.
And certainly there are penalties. There are, misconduct in public office that potentially could be brought forward. No DA is ever going to charge that. I will
Okay.
sit here and tell you that there
Right.
will be, no DA, I mean, except maybe in the most blatant of cases, that there was, some sort of conflict of interest or, personal gain that was coming in.
I've heard of that. So then why are we talking about it?
Because these folks nonetheless swear that they are going to uphold the law of the state of Wisconsin.
But they have the ability and the right and the courage and the purpose to have them here is to make the right decision. So how can a reasonable person put forth a reasonable case and just, let's make a motion and let's have a vote and see how we vote? I mean, is everybody compelled to think that, is anyone compelled to believe in the value that we've presented? Jerry Erdman is an amazing broker. John Ford is building a building in your community. He's built office buildings downtown. I am a very good broker. I'm very ethical. I am representing one of your taxpayers, and I'm doing the best that I can to give you the information that you need to make the right decision. So I hired an appraiser. I went through all those things. I did my valuation work. I came here today. I've got better things to do, just like all of you, but I'm here to get something right. So I just need someone to make a motion and 2 other people to vote for it, so that we can to agree with my value, the 3.5 million, and we can move forward.
Hey, Andrew, is it okay if I make a comment?
You go right ahead.
So I think so I'm not part of from last year or anything, but I want to make a comment about today. And today is,
Yes.
we've had questions that need to be directed at the appraiser. He's not here. I think that it's also makes it challenging, right? Meaning we need some testimony from him. I understand you said you were gonna on a phone, but we don't have the ability. We didn't know, right? And then, to be honest with you, from my perspective, also whether here nor there, the owner of the building too probably would have helped as well to help maybe understand. I mean, I get the concept and everything from my perspective, but I think some of those questions that we need to ask are trying to get answered, right, to come up to a conclusion. I think some of them are just not being answered, or can't be answered because the appropriate people aren't here, right? And I understand you're trying to represent that, but so I just want to make a comment about that.
That's fair. Is there anything else that you'd like to discuss?
The underlying issue that I'm hearing is the assessor is valuing it as an ongoing concern, whereas the taxpayer's rep is valuing it as a shell, as a non-ongoing concern, and I think that's potentially where the difference, or a good part of the difference in valuation may
Right,
lie.
and this is
I
why I'm
agree with
bringing
you.
this up. If you want to make this argument, realistically make this argument and have someone make the decision where it would get dropped to this valuation, you have to do it through circuit court. We can't do it here, regardless. And this is not what I want to be telling the taxpayer. It's not what I want to be telling you, Steve. I don't make the laws for the state. I don't make the statutes, but they're in place. I have to uphold Mike's valuation of this building, even with all of the evidence that you presented today. You have everything that you need to go to circuit court. You could call the gentleman who made the appraisal as an expert witness. You have everything that you need.
It costs $1 gazillion.
I know, and that's
And
unfortunately
you're
the
just-
state
you're
of
just-
Wisconsin has made it that if you're not a gigantic big box store like Walmart that has millions of dollars to go argue in court, that it becomes very difficult for a small business owner like this to do it.
So
I don't
let's
get to
fix
make
it
that
here.
decision,
This is
though.
part of the process. There's no way that this can be the intention of Board of Review in our state of Wisconsin. There's no
Unfortunately,
way.
as it stands now, it is.
Just make make a motion and just a vote on it, and we'll move on, and we're good. And it goes away. You guys can fix it. You're all important people with valuable opinions. You don't have to be afraid of government.
Fear is not the proposition here.
Right.
And telling us that if we don't choose your side, we're cowards. And I somewhat resent that tone.
Yeah, I appreciate it, and I don't mean it to come out that way,
Well, it
Jerry.
is. It's
No,
coming
I
across-
know, but I just feel like it's being presented that legally you can't agree with me. And I know that's not true. And so if you believe in the 3.5 million and all the people that came here today to present the case and the resources and the time and the effort that we've put through, then let's just agree with the 3.5. And if you think the cost basis is the right way and that it's not, and that you just disagree, then I guess, don't do that. I don't want to make anything personal. I'm just trying to make it easier to try to get to the right value because I believe in it.
So the follow-up to my previous discussion, let's talk about what the law requires of you folks to do. What the law tells you is that you are to presume that the assessor's valuation is correct unless the taxpayer presents sufficient evidence to allow you to determine that that assessment was not correct. And that there is then the second question of, did they even give you enough evidence to value, to place a value on the property? Typically, those are one and the same, although I will tell you that we have had instances where there's enough evidence to say that the assessed valuation is incorrect, but that the testimony doesn't go so far as to establish that the taxpayer's value is right. I don't know whether you feel that that's the case here or not, but it certainly could happen. That's rule number one. What rule number two is that as we're looking to make that valuation, the statute tells us that the way we value property is we look at comparable sales of comparable properties. If there are no comparable sales of the property or of comparable properties, then you're able to move on to other methods of valuation, the cost approach, the income approach. So certainly one of the questions you folks have is the very real discussion that Mr. Trout and Mr. Grote had during the course of his questioning. This is a unique property. Does that impact the ability to identify comparable sales that are truly comparable or not? Another question that you face, I think, is the evidence that you have, at least as to the comparable sales in this case, is presented in an appraisal report without an appraiser here to testify as to what those differences are. I will tell you that there are certainly some boards who will nonetheless look at the appraisal and put weight to that appraisal. There are some boards that will look at it and say, because the appraiser is not here, we have no ability to judge whether or not these are truly comparable sales, because we don't understand maybe why an adjustment is made or why it wasn't made, why we selected this comparable sale over a different comparable sale, those types of questions. That ultimately is a question for you. How much weight do you want to put on the appraisal in light of the fact that the appraiser is not here? State law tells you you can ignore it because there's no person here to do that. But that ultimately is a question for you to determine how you want to go. And so that's what the law tells you. And if you're able to answer those questions in a way that you find that the assessor's value is incorrect because of any of the testimony that you heard here today, Mr. Trout is absolutely correct. You have the ability in that case to make a motion to change the assessment. If you find, based on the testimony that we've received, that you can't do that, then you can't. Or you shouldn't, at least. Again, I will tell you that there are certainly boards, I'm sure, that nonetheless will make the motion and just give the taxpayer what they want because that's the way they are. I would submit those boards are not doing their duty under state law. They are not upholding that oath that they swore to do. But is anybody going to get in trouble if you decide to do that? Not a chance. The only likely outcome of that happening would be that the city itself would decide to appeal. They can hire another attorney. I couldn't do that because I've represented you folks today. But they could hire another attorney. They could appeal the determination of this body just as Mr. Trout could challenge that determination. And to do that, you folks won't get in any trouble for doing that, certainly. But you're not upholding your oath that you took when you took your position.
I just want to say I appreciate the explanation and the clarity.
Anything else? All right, I'll move to close open discussion. And then all we have left is to make a formal motion here to either approve or deny the valuation that's been presented in front of us today. So I will make that motion to either approve or deny, and I need a second.
Which way are you going?
Well, we need to vote on it, so,
He's just closing the,
yeah, so.
So you're looking for a motion?
Yeah, so if you're, so the specific motion, in my opinion, after hearing all of this evidence, is to move to strike and deny this valuation and to uphold what the assessor has valued the property at.
I would second that motion.
We have a motion by Andrew Druzwicki, a second by Jerry Willahowski to sustain the assessor's assessment. James Jaworowicz,
Aye.
Michael Braswell,
Aye.
Donald Reed,
Aye.
Jerry Willahowski,
Aye.
Andrew Druzwicki.
Aye.
Motion carries unanimously. Just a determination.
yeah, she's filling it out right now.
Yep, I do. Or do you have that already? Okay, great. Then I don't have to. Mike, did
Mike?
you have a copy for me too, right?
You betcha.
Steve, I know, I guess we're off the record now. I seriously suggest that you consider talking to Penny about, formally filing in circuit court on this matter. If we continue to have the same discussion going forward year after year, I'm going to be in the same boat unless the state of Wisconsin makes a decision that allows us to do something else. And I know you have your opinion on what you believe we have the ability to do. It is the best case scenario at this point. It's not the best case for you, of course, but there's nothing else we can do for you here.
Thank you, though. The things that are economically feasible, but I'll continue to work with Mike and his team, and we'll make some progress. Okay, thanks,
Understood.
guys. Thanks for your time.
So now we have BT Layton.
Yes.
Have his appraiser here, and got all these other guys to come as buddies, and he wouldn't have the appraiser to come.
Mr. Fisher? Apologies, I know it's almost 10:30. I appreciate you waiting.
Yep, no problem.
So I believe what we have in front of us is an extraordinary circumstance to hear your particular case, and I believe that is due to the fact that you did not get information that you would normally have to make this complaint on time. Is that correct?
Yeah, well, we had an appraisal done for refinancing, and then, I'm sorry, had an appraisal done for refinancing not that long ago, and then shortly, like a week or two after that, I think I called the city and inquired into the process, and then by the time I heard back from the assessor was June 25th or so as to what their valuation figure was, and so at that point in time, it was already then, so apparently normally I guess this stuff would have been started earlier if I would have had the information, obviously, earlier.
Generalized gentleman, in this particular case, regardless of the fact whether or not he got bail or anything else late, I'm open to hearing his case unless all of you do not want to or disagree. The state statute basically says that we can deny the hearing even with his explanation, but I see no issue with hearing the gentleman in the event that you're all open and willing to do that.
And I am new to this. This is a whole new experience for me. So I wasn't familiar with the process.
Unless you have anything else to say about that, Brian.
No, I mean, I can do my usual annual thing when we get these requests where, there's a difference in the statute. Statute says that you must grant the ability to proceed with an objection if they appear within the first 48, or within the first 2 hours of the Board of Review meeting, and they show what's called good cause under the statute. If they fail to meet that time frame, which is the case here, then what the statute says is that you may notice the difference between must and your ability to. You may do it, provided that they provide evidence of extraordinary circumstances. And so that suggests to me that there's some difference too in terms of the level of what, the type of evidence or the reasons why you would grant that request. But at the end of the day, it's a completely discretionary determination in terms of whether you want to do it or not, in light of that may language.
Tim, I'll preface by saying you just saw what we went through with another property. You've been sitting here. Do you want to be in front of the Board of Review, and do you want to bring a case just like the previous business owner did, or would you rather us grant a waiver in the event that we do approve this for you to go to circuit court and argue that point?
Well, I certainly wouldn't take it that far, probably. Probably wouldn't be worth my time and effort. And if I assume that if I don't get an opportunity this go around, then there's a chance next assessment year is the process.
Do the appropriate process, yes.
Yeah.
And quite honestly, sir, given that you are here, and my guess is you haven't done all of the evidentiary information that the previous person did.
You are correct.
It's going to be very difficult. It'd be almost impossible for us to say that we're going to be able to change anything at this point. So I'm not trying to say that you're going to waste the board's time. I don't want you to waste your time with the knowledge that you need to bring these things to our attention and have them available for us if we were going to go through with a full hearing and approve this. If you're not confident in being able to do that, you're not confident in having special witnesses, other information and appraisal other than the one that you just spoke about, there's a good chance that we'll continue to have to do what the state statute says, which is to uphold Mike's valuation of the property.
Is part of the process that that you deal with the assessor initially and try to address it at that level, or?
So, go ahead.
Certainly, the statute contemplates that process every year. There is, if the assessment changes, a notice of assessment is kicked out, tells you that your assessment has changed. If it doesn't change, you don't get that notice. Irrespective of whether you get a notice or not, you always have the ability to really at any point approach the assessor and say, hey, we have these issues. There is a special period in the statute that expressly allows you to do that, although, as I say, you can certainly are free to do it at any time. That's called the open book period, which is typically a couple weeks before the Board of Review first meets, and that's your chance to formally go in and make the request. You don't even have to do that. You can do it informally at any point as you're moving forward, and then if you go to open book, or even if you don't, then you have the ability to file the appeal just like you did today. And that applies every year. Okay. Even if nothing changes, you can come back year after year and make the same arguments if you really want.
Provide some background.
My property is not as complicated as the previous one, I do believe. And my only question was, we just had the appraisal and there's like a 25% difference. And if I figured it out based on the notice you gave me, our appraisal was $880, and if I take your assessed value and looked at the prior year tax bill to get to the fair market value, or the estimated fair market value, we're looking at $1,240,000 roughly. So that's quite a big difference on a fairly simple property. So I was just wondering, why is such a big discrepancy? And I don't know if that's a discussion for here, but that's that was kind of the only evidence that I brought, was the appraisal that I provided the assessor a couple weeks ago, a month ago, whatever it was.
Tim, I know you're bringing the fact that you believe that the assessment is wrong, but I think what would be best in your case is that you actually do some sort of review with Mr. Grota and then adequately prepare for doing something like this in the next calendar year, unless you'd really want to try to do this at the last minute. That's my personal opinion. It's not an expression of whether or not you should be doing anything. But that's my thought on the subject as the person that's chairing this board at this point. Because I think you'd get a better explanation from Mr. Grota himself, specifically on why it's been valued the way it's been valued, and that may address the concerns that you're more than likely going to bring up in front of the board to begin with.
Okay, well.
Does that make sense?
Yeah,
Okay.
It does, I understand. Like I said, I'm not familiar with the process. I'm just a little small business owner that happened to buy the building that I was previously renting at some point in time. Thought it'd be, why not, but.
Best case scenario is to become familiar with that process. Please speak
Yep.
with Mr. Grota. I'm fairly certain he'd be happy to speak with you going forward. Now, again, I can still grant the hearing. We're here right now, but in the event that you still want to do that. So, and more or less, is that a yes or a no?
Well, I sort of wouldn't have anything to lose, right?
No, for the time being.
But I have a funny feeling it'd be, kind of, I have a funny feeling what the outcome would be here today. So, I guess I'll go further with Mr. Grota and go that route, I guess, then.
Okay. Given what Tim has requested, then I just move to, or make a motion to deny the hearing based upon what he'd like to proceed with.
I second that motion.
Motion by Andrew Juzwicki, second by Jerry Willahowski to deny the hearing based on what he will go forward with in discussions with Mr. Grota. James DeWorowicz,
Aye.
Michael Braswell,
Aye.
Donald Reed,
Aye.
Jerry Willahowski,
Aye.
Andrew Juzwicki.
Aye.
Motion carries unanimously.
And Tim, I just want to make certain so you understand, I'm not sitting here trying to take away your right to argue in front of the board. It's very difficult to prepare for something like this, and in all good honesty, there is very slim chance that the board can actually make a decision in your favor because of the state statutes in place. There is a minuscule amount of rules specifically pertaining to, let's say, a dilapidated property that needed improvement, where you would get a temporary break to provide those improvements. That's something that the board does have the ability to work with on a temporary basis only.
All right, well, yeah, there's always next year. So, all right, thank you for your time.
All right. If nothing else, are there any other matters?
We will
So-
have to set a future date.
Yeah, we have to set a future date. We have, and this is completely my fault. I take full responsibility for it. We had the 3 properties we were going to do the subpoenas on. I did the subpoenas. I thought I had emailed them to the clerk and to the chair to process. I never did. I don't know what happened. And so we didn't get those until last week. The issue came up, hey, what happened with the answers? And we looked into it and saw that we didn't send it. And so we just need to schedule another meeting date to allow us to do that. I would suggest, depending on Mr. Grota's availability, that we'd look at something like the end of August or the first part of September, which would give the property owners sufficient time to respond to the subpoenas and go from there.
Jeff?
So September. Well, all of the Wednesdays for September for myself will be fine, assuming we're going to do it at the same time at 9 a.m.
Tim and
Currently.
Mike,
15th is the only day.
we're just looking to schedule the next date. Can we just quick do that and then maybe you guys can go back to? We're looking to just schedule the next meeting because of that subpoena issue. So I've suggested that if we looked at something late August or into the first part of September, that would give sufficient time for a response. I don't know what your availability is. I know we're going to have a heck of a year in Mequon, which starts right about then, but.
It's going to be very bad. But
Really?
It starts on the 9th.
9th of September, yeah.
And then I don't know what dates they go after. Late August, I don't have a calendar in front. I did bring my phone.
I can't do late August, I'll be out
Do you
of
want
town.
to see the, oh,
The 9th. So that'd be like the 22nd? So August, the week of the 23rd or the week of the 30th, I think could well work
Brian, you wanted to
in August.
go into September though, didn't you? Or not?
No, I think late August would be fine too. I just need to know the date so that I can give them sufficient time to get it to us, but sometime before the meeting, so.
Now, right, once the subpoenas are out, waivers are likely to be issued. So I could have another colleague sit in, so pick a date that really works for you.
Yeah, that's a good point. Certainly, one of the reasons why we did the subpoenas was to determine whether or not we were going to look at a waiver, and in light of the anticipation that this may be more complex than we anticipate, so it may be a very quick meeting.
Okay. I know we just said August, September 1st. Are you all available that Wednesday? I mean, it's really just a few days later at 9 a.m. Would that work for all of you?
Yep.
Okay. Would September 1st at 9 a.m. work for you, Mr. Grota?
September
1st at 9?
Sure.
Okay. As long as everyone else is on the same page, then I'll move to make the next meeting that date. So that'll be September 1st at 9 a.m.
all right, so we'll set it.
All right. Other than that, was there anything else that we needed to discuss? Is there anything else that I need to sign before I close?
No.
Okay. And then I will move to adjourn the meeting this morning at
Second.
10:45 a.m.
Motion by Andrew Chuzwicki, second by Jerry Willahowski to adjourn. James Jaworowicz,
Aye.
Michael Braswell,
Aye.
Donald Reed,
Aye.
Jerry Willahowski,
Aye.
Andrew Chuzwicki,
Aye.
and it is 10:45 a.m. Thank you.
Jennifer, can we leave these packets for shredding rather than